Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Friends, we are now discussing very good case dealt with by Honorable High Court of Jammu and Kashmir regarding absolute privilege to a lawyer. The problem is whether the statement of the lawyer made during the judicial proceedings can be taken as a defamation, can be taken into account or not. The court said no, it's an absolute privilege to the lawyer to argue whatever he likes in the court, and it is for the court to decide whether to take it to consideration or not. While dealing with the case of peculiar case, PO versus VP. PO versus VP, that means the details are not supposed to be given. You can see the citation in Live Law 2023 within brackets DEL 140. If you are able to get the link, please read the case law clearly. Right, in this case, Justice Mini Pushkarana, she said that the justice system would be adversely affected if the lawyers were in the fear of law themselves. If the lawyers were in the fear of law themselves. Friends, remember when I was telling you the professional ethics class, I told you, suppose if you go on filing cases, then if the doctors are, they have to pay compensation. A doctor with quivering or shivering hands cannot perform the operation. కేసుల మీద కేసులు మీరు వేస్తూ ఉంటే అలాగే ప్రతిదానికి తప్పులు పడుతూ ఉంటే డాక్టర్ ఆపరేషన్ ఏం చేయగలడు, అమ్మో ఏమవుద్దో, ఏం కేసు. అలాగే లాయర్స్ కూడా ఏం మాట్లాడితే కేసు ఏమవుద్దో అనేటువంటి భయంతో ఉంటే దే కెనాట్ ఆర్గ్యూ ద కేసెస్, రైట్. Therefore, Honorable Justice said, any statement made by the lawyer would be protected under absolute privilege. That means the statement is in public interest, therefore absolute privilege will be a complete defense. Why this thing happened, let us but know. The senior advocate, while submitting his arguments, he has literally stated some defamatory statements against a businessman during the course of arguments. Yes, no doubt we'll say. In so many occasions we will be saying that, Your Honor, that village is notorious for that caste is notorious for that. They have done it. This because these people are politically superior. They wanted to gain advantage. They have killed him. Like that we will be arguing the matter. So normally the stage will be double unnal sir, edana zarugudi. They can manage anything. That man is a businessman, great businessman. Em cheyagalaru evadana? These things normally you utter. So the senior advocate, something, he has spoken something against a businessman in the open court during the time of arguments. So basing on the arguments or verbal oral arguments, the businessman, of course he's a lawyer, filed a civil suit or filed a tort of defamation against the senior advocate, and he wanted to issue summons to the senior advocate. So therefore the senior advocate has approached the Honorable Justice Mini Pushkarana. She stated that no doubt according to section 122 to 126 of the Indian Evidence Act, so many privileges they are there. The privileged communication between advocate and client. If the client comes and says, yes, my dear lawyer, I have killed so many person, so please get me arrange bail. Yes, you should not tell him that what transpired. Wife and husband communications, likewise so many communications are there. But here the point is whether the communication made in the judicial proceedings, whether it amounts to defamation or not. Absolutely no, because if there is any actually material which cannot go on record, the judge using powers right from 144 to 146 of the Evidence Act we are telling you. So definitely the judge is the arbiter, final arbiter. He will say, no, this argument cannot sustain. Don't use that words. He will say that how can you take advantage of the statement given by the statement argued by the advocate and say that it is defamatory. And secondly, the judge also stated, suppose if you say that it is true, to prove it is very difficult. Suppose if it is correct, but it is very difficult. Who has to tell? Either judge or the bench clerk or the other advocates. Will they tell against their own advocate? It's not. There is no means to ascertain as to what was the exact statement made by the advocate. The CCTVs, they are not there in the court, right? So please remember. So no doubt the businessman says that his fundamental right to reputation is lost. Article 21 says about the right to reputation. So there is no statutory right to say that it is an absolute privilege. No doubt we have discussed it right from 122 to 126. They say that communications between wife and husband, lawyer, client, like that. But the communication between the judge and the advocate, there is no mention of the same. There is no statutory provision. That is the defense of the advocate. Yes, you have to hear that also. Anyway, judge says, so it is absolute privilege, whether it is relevant or not, whether it is irrelevant or not. So the statement made by a lawyer before the judicial proceedings, definitely it cannot be subjected to any scrutiny. The judge has to decide. The other persons, they cannot decide. If that is the case, the system of judiciary system will come to a literal halt. And here the judge also observed there is no malice or there is no motive on the part of the lawyer behind the so-called state arguments. So in the flow of arguments, he might have stated like that. And presently in this suit also, the plaintiff, that is the businessman, is not able to make up the prima facie case. So no summons and absolute privilege is granted, and this is not an actionable defamation. This is not a tort. Of course, he has filed a civil suit. Yes, the civil suit does not sustain. Very beautiful case law supporting the advocates, and a day may come where a rule will be passed that the communication between the advocate and the so-called judge may not be privileged also. We don't know. But anyway, for the present, this is the position. So it is very clear that whatever you argue before the court, it is not subject to defamation. If you learn this much, it is sufficient. Thank you very much.